Welcome back to another courtroom update. Today we're covering the case of State of Texas versus Kevin Owens. This case involves several important developments: a lawyer requesting to withdraw, questions about financial hardship, and multiple courtroom motions that could affect the outcome. Why is Kevin Owens' attorney asking to step down? Will the judge allow it? And what could this mean for the future of the case? Let's break down the key moments, the legal rulings, and what might happen next.
Via third party or directly?
Oh, just one second. Let me call the case and then we'll. All right, court is calling 2021 CR 1906, State of Texas versus Kevin Owens. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Orlando Castaño for defense.
And are you Kevin Owens?
And so that is what I'd like to address is he is of the opinion, because the proceedings are live streamed, that any statements he makes is him communicating to whoever.
All right.
So he was asking for an order that he be allowed to speak while in court.
I mean, I'm asking you a question, so obviously I want you to speak. Are you Kevin Owens? That's either yes or no.
Yes.
All right. So there has been a motion to withdraw attorney.
Yes, Judge.
All right.
And so I also followed the motion to modify conditions. I'm not sure whether you want to address both.
Well, let's address the motion to withdraw first, and then we'll see if we get to the other motion.
I've represented Mr. Owens now for just over 2 weeks. We met last week at my office, and during the duration of our my representation, he and I have had differences in regards to how to proceed on this case. There has been, I believe, a strong difference in opinion on how to proceed. He's asked me to do things that I do not agree with. And in that disagreement, because I've not wanted to move forward the way he's asked me to, he's notified me in writing that I was fired. And so he asked me to file a motion to withdraw.
Here's where the tension spikes. Kevin's attorney has officially asked to withdraw from the case, claiming fundamental disagreements with his client. In legal terms, this isn't just a casual dispute. This means the lawyer believes he can't ethically or professionally continue. Judges often hesitate to grant this so close to trial because it can delay justice. But here's the twist. The lawyer claims Kevin already fired him. So, whose call is it really? The client's, the attorney's, or the judge's? Drop a comment. Should the judge let the lawyer go or force him to stay until trial?
I've done so. I believe at this point, though, that our disagreements are fundamental and that I cannot ethically represent him.
All right. So, Mr. Castagnol, I believe you're the third attorney on this case.
I believe I'm the second.
The second. All right. I thought there was someone before Miss Gay.
Ms. Gay, and I believe she was the first lawyer on this.
Let's see. All right, can you look in the record and see if Ms. Gay was the first attorney on this case, please? All right. So this is scheduled for trial October 9th. So your motion to withdraw will be denied. Mr. Owens, if you wish to hire another attorney, you're more than welcome to do so. But whoever that attorney is, they're going to need to be ready for jury trial on October 9th. So,
and just like that, the judge shuts it down. Motion denied. This means, despite all the drama, the lawyer stays on the case, at least for now, and the trial date. Locked in for October 9th, no delays, no excuses. The judge is clearly sending a message. The justice system keeps moving, whether the defense team agrees or not. But here's the question. How effective can an attorney be when the client doesn't want him? Legal experts debate this all the time. What do you think? Is forcing a lawyer to stay fair or a recipe for disaster?
Judge, I don't believe I can ethically, again, as I stated, represent Mr. Owens. And I believe that eventually he not wanting my representation, I believe that this is an issue that's an appealable issue. And I don't believe that I can ethically be his attorney at this point.
all right, motion is denied. The next motion is the motion to modify or delete bond conditions.
Yes, Judge.
All right. Counsel, you want to address that?
Yes, Judge. We've asked, my client is indigent, as you know, that I have been appointed on this case. And previously, I believe Ms. Gay was appointed. I'm not certain of that, but I do know that I have been assigned to represent him. He's asking that his GPS fees be waived because he is indigent. I did not put this in the motion. I forgot to add this, but I did speak to the state in regards to his request. He also would like to have drug test fees waived because he is indigent. And so he has recently had to provide a drug test, and it cost him $10, and he's struggling to have money. He's not been able to work. The other issue he's asked me to address is that he'd be allowed to have tracking only. And the facts of this case do not demonstrate that he has gone to any individual's business, home. These were all through electronic communications. And so I do not believe that GPS is necessarily something that's going to prevent any of those types of issues. So we'd ask that tracking be allowed. He's been having a difficult time finding employment. And he did recently find employment with Toyota, but his understanding is that he has to have the employer come in and testify as to his employment. And because of that, that was prohibitive, and he was not able to maintain that employment. And so, that condition, if the court does not wish to allow him tracking only, we'd ask that that be removed, or in lieu of in-person testimony, that there be some type of ability for an email with company letterhead or something acknowledging that he has been employed. Because he is indigent, he has not been able to retain his own attorney. He can't afford GPS fees, and so it's important that he gets out there.
Now the case takes a financial turn. Kevin's defense argues he's indigent, meaning too broke to afford basic court costs like GPS monitoring and drug tests. These aren't optional. They're court-imposed conditions meant to ensure compliance. But if someone literally can't pay, does justice risk becoming a privilege for the wealthy? The prosecutor agrees on waiving some fees, but insists on keeping full GPS tracking, saying it keeps the community safe. Here's the debate for you. Should financial hardship reduce restrictions, or are public safety measures non-negotiable no matter what?
Be inappropriate. However, if there's something he wishes to say,
I believe
can't
his concern is also just acknowledging his presence, Judge. So any speech that he made or makes, he was under the belief that he would be in violation of a court order.
No, I never put a court order in place that he could not talk. But I will say this. I can't give you any legal advice, but I know that anyone who had a criminal case or any type of legal case would perhaps want to speak to their attorney before they decided to speak to the court. But that's completely up to your relationship with your attorney. So I think that's overly broad. So I'm not going to rule on that.
I think he was looking for an order just allowing him to address the court. Should he be asked to speak, asked to announce it present? And if he were to testify, that he'd be allowed to testify.
Yes, of course he can. If he decides to testify, then you're welcome to testify. That's within your purview to make a decision. A client in criminal court has certain rights. One is whether they enter a plea or not, whether they go to the court or the jury for punishment, whether or not they decide to testify or not testify. So I really don't understand the defendant being permitted to speak while in court, that request, but I'm telling you, you can speak in court. With regards to the GPS fees, I'll ask that those be waived or deferred. With regards to employment, counsel, if the issue with the employers testifying is because there was no documentation that was being brought to the court when there was a issue of whether or not he had employment, and the court wanted to know what employment he had, what the hours were, and what would the job entail. because of the nature of what he's charged with, the court didn't think it would be prudent for him to have employment where he's not at a stationary place.
And I understand that, Judge. I believe that the facts of the case do not warrant restriction of his movement because he's not been, I believe, accused. It's not alleged that he's been traveling to or anybody's residence or business. And so, I mean, it seems to be just a bit of an overreach in regards to restricting his ability to find employment.
All right, so I'm going to order that he has to provide proof of employment, and that includes his work schedule.
And so just to clarify, when you say provide proof, would an email from the letter or a letter from the employment with letterhead, would that be sufficient proof?
But it'd have to have what his work schedule
Correct.
is. Yes, and counsel, I'll depend on you as an officer of the court to verify that that is
Absolutely.
correct. All right.
Just so I'm 100% clear that you're not requiring that his employer come in and testify to such.
No.
Okay.
Big development here. The judge finally rules Kevin can provide proof of employment through an email or letter. No in-person testimony required. That's huge because it removes a major barrier to him working again. But the judge isn't softening everything. GPS tracking stays, drug test fees waived, but freedom of movement. Denied grocery runs and post office visits, also denied. It's a mixed bag of wins and losses for Kevin, setting the stage for a trial with high stakes and limited freedom. This case just keeps getting more complicated.
And then with regards to him being permitted to speak while in court, sure, he can speak while in court. With regards to tracking only, that's denied.
And I did list it in there, but there's space for it if the court approves permission to waive any drug testing fees. I don't know if the court has the ability to do that, but
I will waive drug testing fees. All right. Is there anything else with regards to this motion?
right. And so he has been including me on emails. He does have household duties such as going to HEB. And so, you know, he would like to be able to go at least once a week to get groceries. He did ask for permission to go to the post office. And so I believe he would like to at least be able to go because he's been having them delivered, which is a fee.
Mm-hmm.
And it costs additional monies to have those groceries delivered. And so he would like to at least be able to go to HEB and pick them up.
All right. That will be denied. Is there anything else?
Good judge.
All right.
And there you have it. The courtroom drama of Kevin Owens continues with motions denied, fees waived, and trial day approaching fast. The defense wanted freedom, the prosecution wanted control, and the judge delivered a split decision that keeps both sides guessing. What's next for Kevin Owens? Only time will tell when October 9th rolls around. But one thing's for sure, this courtroom isn't done making headlines. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.